So the process is what we're concerned about here. On Monday night, the House convened a meeting of the Rules Committee with 8 minutes notice. The Freedom of Information Act requires 24 hours notice for any meeting of a public body. There was no basis for them to waive that 24-hour requirement, and so we believe that that is a clear violation of the South Carolina Freedom of Information Act.
And you also noted the emergency circumstance that the House Speaker has the ability to do, but saying it was not noted in the agenda. Can you explain that part?
That's right. So under the Freedom of Information Act, there is a provision that says if there's an emergency, then you can waive that 24-hour notice period. There is also a provision in the House, their own rules, so they have their own separate rules of procedure, and Rule 4.4 says that in exigent circumstances, the Speaker of the House can decide if he wants to waive that 24-hour notice period. But that Rule 4.4, before you even get to the exigent circumstances, says that there should be 24 hours notice for every meeting. It's only if there's an objective emergency, not determined by the Speaker. He doesn't get to determine what's an emergency. If there is an emergency, then he can determine whether or not to waive the 24-hour notice.
Can you just talk about the importance of you all challenging this and really speaking up to sue lawmakers after yesterday's meeting?
Right. So, as I mentioned earlier, what we are concerned about is that the process is followed properly and that everyone, citizens, legislators, the Speaker of the House, everyone follows the same law. What we've seen over the last 10 years is a decrease in the rule of law. And that means that legislators, the executive, certain sectors of society are not being held to the same standards as everyone else. And when that happens, you tear apart the fabric of society. What we're trying to do here is to make sure that everyone has to play by the same rules, the same laws, and so that everything is fair, open, and transparent.
And a lot of eyes have been on the House as they look at that redistricting that's been at the forefront in controversy. Many will probably argue that this lawsuit is to stall the specific vote or that specific topic. Can you just kind of address that as well?
Yeah, so that is, I can certainly understand why someone might argue that, but that's not what we're doing here. If we were going to be doing that, there are a lot of other ways that we could have filed a lawsuit that would challenge the redistricting as it's ongoing itself. So we are not doing that. We're not challenging the redistricting process at this point. All we're doing is challenging how they came to create this rule. So we're really trying to keep it narrow and focused, because what they do at the State House, how they vote, that is a political question. Courts don't get into that at this point. What we're focused on is what the law says. And Jace, you might answer that better than me.
Absolutely. My name is Jace Woodrum. I'm the Executive Director of the ACLU of South Carolina. Let me tell you what lawmakers did. Lawmakers hid a meeting to change the rules of debate, to silence the discussion in order to rush through rigged maps, period. The law says you have to let the public know when public bodies are meeting. That's clear. There is no emergency that allows the waiver of the 24-hour notice requirement. Any supposed emergency is manufactured by the legislature's attempt to rush through new maps before an election. Notably, the election has already started. Notably, the United States Supreme Court has already upheld our maps as constitutional. There is no emergency except what they claim to be an emergency. The public deserves to be a part of this process because democracy dies in darkness.
And can you just give a response to their argument that the House Speaker and the House has the ability to, govern its own policies and processes, and that they are not required to note any emergency in any records?
The House of Representatives cannot ignore state law. The Freedom of Information Act lays out specific requirements for legislative bodies to ensure government transparency. That's what this is about. We are talking about a monumental change in policy. If this new map is passed, there are South Carolinians, about 37% of them, who will wake up and be in a new congressional district. That is a consequential matter, and people should be a part of the process. They should be able to attend hearings and let their voice be heard. Without public notice, they can't. 8 minutes is not enough. I even heard from some lawmakers that they couldn't get over there in time. Reporters couldn't get over there in time. My staff at the ACLU couldn't get over there in time. That is not government transparency, and that's what we're fighting for.
And I can speak to your question. The term exigent is not defined in statute or in the rules. So when something's not defined, that means that the word means what a reasonable common person would think it means. So I think people typically understand exigent to mean something is urgent, it has to be done quickly, or if something terrible is going to happen, that you have to take action immediately. So for there to be an exigent circumstance, there is objectively nothing. There is no requirement that the speaker put on the record that what he determined to be an exigent circumstance. But the rule requires for an exigent circumstance to exist. If there's nothing in the record, then it doesn't exist.
Do you mind spelling out your first and last name for me?
Jace Woodrum, JaceWoodrum.
And can you just clarify what you're asking for remedy as far as resetting the clock, as you put it?
Yeah. So what we want the court to do is to invalidate all of the votes that were taken by the House yesterday, first, second, and third reading, and to put the debate back to where it started on Monday.
And just want to make sure I understand, you also mentioned some attorney fees in there.
That's right.
With that 8,000, just clarify that for me as well.
Yes. So the FOIA statute provides that if you prevail, if you win, when you sue a public body for violating the Freedom of Information Act, you can get your attorney's fees paid. And so we are attorneys, we charge fees, and what we gave to the judge is a list of all of the time that we've put into this case from yesterday morning until now, with our hourly rate beside it. Multiply the hours times the hourly rate, and that's how you get the 8,800.
Anything else you all would like to add?
It's really important that government is transparent and open. And that's why we've asked a judge to get involved here today. When lawmakers go into hidden meetings to make decisions that impact all of our lives, it hurts democracy. We really hope that we have a judge today who sees that and takes the appropriate action.